Hi everyone, I've got a bit of an easy gig today. I'm chairing a great paper. We're moving from finfluencers, where you're trying to influence corporate governance through your voice, to, if you're just a bit tired of it all and you want to leave, shareholder appraisal rights in China, and comparative to Japan and the USA, Robin Huang from Chinese University of Hong Kong, and commentary from Christopher Chen, National Taiwan University. But I won't speak long, I'll hand over to our presenter.
Good morning. It's so nice to visit Singapore again after COVID, several years, 5 long years. Okay, this morning I talked with Virginia. I think it's a long overdue visit. And so happy to see so many old friends and also new friends. Today I'm going to talk about appraisal right, probably not as interesting as the previous fintech thing, okay? But before I get started, let me say a couple of things. First, congratulations. Congratulations to Dan on the establishment of this very important forum. Okay, this is also good for all of us, okay? And also congratulations to Professor Kim on receiving this very important distinguished professor award. You set a very good role model for all of us. Thank you. And second, my apologies. I'm not sure whether you noticed this or not. My paper, actually, is that put on the online or not yet? Okay, you can see that is absolutely first draft. It's still with comments on that, okay? So, and I just also sent in my PPT this morning. So this created a huge difficulty for Chris. Okay, so my apologies. But this shows this is a genuine work in progress and a genuine conference paper, right? Conference paper meant to be work in progress to seek comments from conference colleagues, right? It's not meant to present something you already done well enough, already published, right? So I would welcome all comments from you guys, because the reason I sent in so late is, one is so really busy these days, but more because this topic I think is quite difficult, and I have not yet made my final decisions on many issues I'm going to discuss, even now, okay? So I'm open to any comments, okay? And I will appreciate that to help me further improve my paper. So actually a lot of issues to cover, but I know I have only 20 minutes, right? So I will need to run through certain part of the paper quicker than others. So I will first the introduction and the background, and then the interesting part will be the empirical findings. And because I will look at all relevant cases in China to see the features of those cases and what the problems those cases may tell us about. And then a critical evaluation, and then comes the comparative part. Okay, I compare with US and Japan, and just earlier I talked with Chris. Chris said, there's also a big value in comparing with Taiwan, and I look forward to that. Okay, and also the suggestions. This is the difficult part. As I said, I have not yet made my final decisions. So appraisal remedy, this is a room of expert. I don't think I need to explain what that is. Why study China? Appraisal remedy is developed in the US and as a protection tool for minority shareholder. And this is particularly important for China, given that China is categorized by a higher level of ownership concentration, and the agency cost is mainly the conflict of interest between majority and minority shareholders. So there's a lot of problem in this area as opposed to the conflict of interest between shareholders and management, as is the case in the US. Okay. And the elements. So I'm sure many jurisdictions have appraisal remedy, but they are different in many ways. And the element of those, those elements actually may make appraisal remedy very different, even though we are talking about the same thing, appraisal remedy, but they may actually very different in substance or in practice. So we need to look at the scope of event which may trigger this remedy. So in what circumstances you can seek appraisal remedy, and the procedures you need to follow, and the method to value the shares, because you need to buy back shares from the dissenting shareholder, then how much money, right, you need to pay, and also exceptions. And finally, there is a very big issue in mainland China, that is the relationship between appraisal remedy and the capital maintenance doctrine. This may or may not be a big issue in other common law jurisdictions, because you have very much relaxed the capital maintenance doctrine, but in China it's still very tightly regulated. So when you buy back shares, you cancel those shares, that would amount to capital reduction, and that can be quite difficult in China. Recently, we revised our company law 2023, okay, and then we'll ask ourselves what changes we have made, okay, to appraisal remedy in this round of reform. Is that enough or not enough? So I will apply a mixture of research method here, including doctrinal analysis. Basically, you just look at the black letter law, and then empirical study looking at the cases in practice, and finally compare. Okay, that's why we come together, right? And historical background, I will skip this part. Basically come from US and then spread to other jurisdictions, and including China. We introduced that one in 2005 when we had the overhaul of company law in that year. And even though later on we had some revisions or amendment to the company law in 2013, 2018, but that minor, okay? Now, the first feature of our appraisal regime is that the remedy, depending on the type of company is concerned. Okay, so it's a limited liability company or joint stock limited company. So for comparative purposes, limited liability company corresponds to a private company in Commonwealth jurisdictions, and the joint stock one to a public company. Okay. And there are circumstances, okay. According to Article 74, there are 3 circumstances under which LLC shareholders can seek appraisal remedy. First is 5 years, no profit. 5 years, no dividend, okay? You continue to make profit for 5 years, but refuse to pay dividend. Second, merge or split up or transfer major properties of the company. If the minority shareholder are not happy, they can seek appraisal remedy. Or finally, the term of operation expires, and then majority shareholder want to carry on to extend the term, but minority shareholder not happy, then they can exit the company with a fair price. Then for joint stock company, JSC, as you can see, there's only one circumstance, that is to merge with others or split up. So compared with LLC, there are much less grounds for seeking appraisal remedy. And also procedure rules. We just mentioned this is a big conflict between majority and minority in the shareholders meeting. So procedurally, minority shareholder need to participate in the shareholders meeting and vote against the resolution to do those things we just discussed earlier. And then you need to negotiate, you're not happy, and you negotiate with the company, and within a certain days, and then you can bring the case to the court. So there's procedure rules here. And as you can see, it's pretty rigid. Okay, 60 days must be 60 days. Okay, cannot be one more day. Okay, so, and this has become an issue actually in some cases if you bring this, without complying with all those procedures, you may lose the case. Okay, and of course, then the issue is how to deal with those procedural issues. And in 2023, just this new company law, by the way, this company law will come into effect this July, so not yet effective, but it will just be a couple of months time. There's, for the new provision for JSC, no change at all. It's a faithful copy of the predecessor. But for LLC, there is a difference. Okay, the introduced one. If a controlling shareholder of the company abuses the shareholders' rights with prejudice to the interest of the company, then they can request the company to acquire this one. So this comes as the fourth circumstances for seeking the appraisal remedy, right? And there's another one. Actually, it's not meant to be appraisal remedy, but it's functionally similar to appraisal remedy. So I covered it here. It's a simplified merger. So a parent company can merge with a subsidiary company when it holds more than 90% shares. This is actually it's called a compulsory buyout. Okay, and in this circumstance, the minority shareholder can request appraisal remedy. So this one, as you can tell from the number, this one is not in that same part of the company law as the previous provision I mentioned. But this one, I think, if you compare with U.S. law, you will find that this one is actually equivalent of appraisal remedy. So this is the, I think, the point, about comparative law. So we compare not, like a formal convergence, but also functional convergence, right? Now, empirical findings, I just, look at the cases, and you can see that's the cases I located. In the early years, as you can see, the 2005 company law came into effect in 2006, but in the first several years, there were very few cases, and started to pick up from 2014 or 2013. Why? Well, it's my own interpretation. That's because in 2013, we reformed the law, the company law, to reduce the cost of incorporation. So many companies, a lot of companies, established because they reduced the cost of incorporation, and also some other reasons. And the geographic distributions of cases. So 5 of the regions, province, Jiangsu, Shanghai, Shandong, Guangdong, and Zhejiang, all economically developed regions in China, together account for like more than 40% of all cases. And this, of course, again shows that this because more companies in those provinces, so naturally more shareholder dispute there, and there's a need for such appraisal. And the shareholding ratio, not surprisingly, most of the cases, the plaintiff is minority shareholder. They are less than 50%. And the statutory ground, as I said, before the recent reform. Oh, by the way, my empirical study just look at the cases adjudicated before this recent reform, because my purpose is to judge how the old system has been functioning in practice and whether this reform has done its job properly to address problems in practice, and whether there's any further room for reform in the future. So I just look at that one, so not mix them up like the old one and the new one. So statute ground, still 3, and you can see the first circumstances account for the most cases in practice. No dividend for 5 years. Dividend payment in China is a big issue, particularly in the stock market, but this is also the issue in LLC. So because just keep the money, locked you in, and you need to continue to play with us, right? And then they can use related party transactions to take the money out. So that's the way to play the game, and that's why you want to get out. And judicial reasons for case dismissal, so whether the case is successful or not. As you can see here, In 40% of cases, the plaintiff failed to demonstrate statutory ground and also failed to comply with procedural rules. These two stand out as the main reasons for failure, okay, for the case, okay, for failure to get appraisal remedy. Okay, so 41. So for why 41% of all dismissed cases here, I think information asymmetry is a big problem because, for example, you say for 5 long years you did not pay dividend, you have to prove that you have made profit. But because you can massage your balance sheet to, to make profit, to away, make them, and then you can show them, see, we do not make a profit, right? So we cannot pay you dividend this year, but actually they may have made profit, right? So it's important to get relevant information to prove that you breached this ground. So in many cases, actually minority shareholders have to first bring inspection rights. Okay, inspection rights, right? That's what the project we did over the COVID, right? Very important to get the information to prove the grounds. Okay, and also for procedural rules. Okay, as I mentioned, for example, you did not attend the meeting. Okay, the 5 minutes left. I need to run quicker. And then there are also problems with others. Okay, probably no time to read. And that's probably another reason why I took it took so much time and I submit this one late. A lot of things to discuss. And the other important issue is stock value mechanism. How to, even if you successfully, like in 81 cases, successfully win the case, but how much money you can receive. Okay, so that's another battle. In 40% of those cases, the court will engage in, outside specialists, okay, like an accounting firm to do the work. And sometimes they can also do themselves, okay? They just use the net asset value to do this. Well, those things actually have a big implications for what I will discuss later, but I'm not sure whether we have time to discuss, so I better not mention now at this point. Now, this, in the US and in Japan, it's possible like you choose a valuation method to get a premium, okay, on the share to be bought back by the company. And actually the premium actually in the US and particularly in the US can be very general, can be very generous. Sometimes it can be as high as to 30%. So this led to the problem of appraisal arbitrage. So some hedge funds just tactically buy shares and then seek appraisal right because this will give you 30% profit, right? It's very attractive. And then later, U.S., okay, this become a bigger problem in U.S., but in China, we do not use that. So some comparison here. Why choose these two? Okay, I know there's many other jurisdictions. I'm happy actually to include more in future. Basically, U.S., always we look to U.S. for guidance, okay, whether or not it's really the best one. And Japan also has a big influence, okay, on Chinese company law, okay, for various reasons. And then this is a snapshot of those elements, okay, China, US represented by Delaware, okay, and Japan. So look at the statute ground and the procedural and also market exceptions here. So you can see actually more statutory ground in China than Japan and Delaware. And okay, another issue here, that's why I mentioned earlier, the simplified merger. I call that, I divide them into two exit when the minority shareholder exit. It's voluntary exit. That's you take the initiative to ask the company to say, I want to exit, okay? But actually you can stay, okay? And the other one is a compulsory exit. You have no choice. For example, it's a compulsory buyout, right? The majority shareholder want to buy 100% of the company and kick you out. And then the only way for you to protect yourself is to get a fair price. In the US, actually, the second one actually is more common, okay, in practice. In China, we just recently added this one, okay, as a matter of law. And also compare the numbers, okay, as I said earlier, we do not have many cases, and the US, in the one single state of Delaware, even more cases than China and also Japan. there's a Delaware, okay. They have, also there's a sharp decline in the US in 2018. That's because of a case, their case. Again, I think I have no time to discuss that case. Basically, that case reversed the trend to giving like a big premium for appraisal remedy to descending shareholder, to the shareholders. So the incentive to bring appraisal remedy dropped significantly, okay, after that. And also in the US, as I said, privatization deals, squeeze out mergers seem to be the main circumstances in which appraisal remedy occurred. You see, that's the descent. In Japan, also a significant increase after 2005 when Japan elected its company law. And also, premium, good, 20%, not as high as US, but pretty big, okay. But there are no appraisal arbitrage issue because they have other well-designed mechanisms, okay. If we have time, we can discuss that further. Now, finally, explaining the difference, can I have just 1 minute, okay, just finish this part, okay. Explaining the difference, why we, provide premium, okay, that's one thing. And also, the procedural rules here seriously hindered the bringing of appraisal remedies, okay, in China. So in practice, the court have been very strict, okay, and to the point of rigid, okay, on those procedural rules, okay. Now, the reason why I want to ask 1 more minute, I want to discuss these non-statutory appraisal cases because in my search of the cases, apart from those cases brought on the basis of those provisions I mentioned earlier in the company law, there are also many cases brought on the basis of the contract. Okay, I call that contract-based, non-statutory, because that actually based on the agreement or constitution provision between the parties. Okay, and this is actually a very difficult issue. That's why I want to ask your opinions. Now, there are many cases. Okay, that's one issue. Okay, and also then the then the issues. Let me ask you several questions in your comments. Now, for those contract-based, okay, as I mentioned, a remedy. Question number one, because I'm still thinking about these issues on the way here, whether they should be allowed, because this is a big debate, okay, among court. Some court allow them, some court not, because they say, you go beyond what is allowed in the law. Now, in those contract-based remedy, some of them actually expand, some of them actually limit the scope. And then again, another issue is whether you can use contract or agreement to restrict the right of the appraisal remedy. So two ways, okay, whether you can use that to expand or to narrow down the scope of appraisal remedy. I know I have a long overtime, so I better stop here. Thank you.
Okay. Thanks for giving me the second opportunity to make comment to contribute to the event. So I'm really happy to do that. And thanks Professor Huang for this wonderful paper. Even though Robin claimed to be the first draft, but if you read the paper, you'll realize the paper has not only the background on Chinese law, also what is exactly Chinese law, also data and practice about China. It also has theoretical discussion on why there must be why there is a appraisal remedy in US or in China or in Japan. It also has a comparative perspective. So as a first draft, I think it's more than just impressive. It has all the elements we need as a good paper, isn't it? Right? And pick up from Robin's last point on the contractual base. And I'm actually deeply fascinated by that phenomenon because in Taiwan it just cannot happen. We cannot expect to have, but it happened in China. So I think it's really something worth to develop in the future. And of course, I don't have a firm view on that yet, but I think picking on the private ordering, I'd love to be something very interesting in addition to statutory remedies. So today my comments are based on largely two angles. First of all, Taiwanese experience on the main thing is about transplantation, and I will share some thoughts on whether we maybe in corporate and civil law Asia should actually probably copy paste from the more UK style unfair prejudice remedy. So first on transplantation, I think appraisal remedy certainly is not unique in China. As Professor Huang had mentioned, there's also similar remedy, and the study by Alan also available in Japan, is also available in Taiwan. And I'm not surprised if Korea also had the same remedy. And I admit I haven't done a deep dive into appraisal remedy in Taiwan yet. But as far as I can see, I check online. In Taiwan, the remedy was available into our company law since 1966. Well, more than a decade before I was born. And the law actually hasn't changed that much. The main body of the law remained the same since 1966. And compared with China, obviously the grounds on the Taiwan law is a bit more limited. As Professor mentioned earlier, in China, the appraisal remedy can apply to dividends, to charter amendments. Those are not available in Taiwan. As far as I can see, in company law, Article 186 of Taiwan's company law is the appraisal remedy is applied to certain major property transactions. In addition, it also applies to certain merger acquisition or takeover transaction in company law in some special statute, but it doesn't apply to some other scenario. So the ground-wise is a little bit more limited. And I haven't done empirical study, but I think Professor Wang's paper offered me actually idea to apply for a grant to study further. Because as Professor Huang's paper mentioned earlier, I think in China it applied to joint stock 有限公司嘛. Right. But in Taiwan, our law only applies to company linked by shares. We have another kind of company similar to China's joint stock company. So it's a limited liability company, but it's not a company linked by shares. So there's a totally separate rule on that. And the appraisal right doesn't apply to roughly 500,000 those limited liability joint stock company in Taiwan. So the scope is maybe more limited. However, similar to China, Taiwan also has some obvious legal obstacles. So for example, our company law, for a dissenting shareholder to apply for appraisal remedy, number one step, he need to send a written notice to the company to say, I don't agree with something, and it's not all, and he actually has to go to the general meeting to say, I vote against. There's a double requirement, dissenting with a notice and vote against, or in the merger acquisition, she can waive the right to vote. And so that means that in Taiwan, a shareholder who want to apply for the appraisal remedy cannot simply vote by his feet. If he failed to show up, then it's gone. So let me explain maybe some cases, there are limited cases in Taiwan about this yet. And similar to China, in elsewhere, how does the court decide to access fair value remain a question. Well, I don't have the data on that, but I actually share some of the stories that Professor Huang mentioned earlier. I was in one of my courses last term, we invited a law firm to give a presentation. One of the lawyers actually mentioned that they did their own study. They said, according to their data, but they didn't share the sources, according to their observations, some those shareholders apply for appraisal remedy under certain provisions. They actually earned quite a lot of premiums. So their suggestion to the client in Taiwan was that once you disagree with something, vote against, give the notice, and the bargain for better value. Actually, they can earn money from that. That link back to Professor Wang's point earlier about arbitrage, premiums arbitrage. I don't have the data for that, but it doesn't seem like it's a unique Chinese problem. I think maybe in the end of the day, it's a problem about the appraisal remedy per se. It offers some incentive for shareholders to do something for their own benefit. And that brings me to the idea that Professor Huang's paper focuses on China, but given that the remedy is also available in Japan, maybe in Korea, maybe some parts of Asia, and it offers the idea of a ground for further empirical study on not just the appraisal remedy per se, but also what happened in Asia when we copy-paste from America. And this is my last slide. So that brings me to my next question. Why do we need an appraisal remedy? As mentioned in Professor Huang's paper, I'm not going to challenge the ground today. I don't have a firm opinion yet as well. However, it's obvious that part of the reason why we have the appraisal remedies to protect minority shareholders, and part of it could be because we don't want the company or majority shareholder to do some unfair practice against minority shareholders. Okay, so on this note, what I'm thinking is that we be better if, like a civil law Asia, we choose, instead of looking at Americans, should we just look at Singapore, Hong Kong, the more UK style remedy? So I have to admit, I came from a civil law background, but since I studied in common law and actually taught law in common law country for too long, so I'm a more common law than civil law. So to me, what the hell is looking at America, right? We do respect to Americans, but for example, Singapore, when Singapore revised the Companies Act, the consultation look at 4 countries: Hong Kong, UK, Australia, New Zealand, maybe Canada, but not Delaware. But in Taiwan, we usually assume Delaware is the king, not UK. But of course, there are more diverse background of professors. So my question is, does it make sense we introduce more English-style operation remedy, such as Section 994, etc., under UK's Company Act 2006, or Singapore is a similar version? And of course, I think arguably on the face of it, there could be some benefits. For example, unfair prejudice in theory can apply to more potential scenarios, right? For example, under Taiwan law, appraisal remedy only available for certain merger acquisition or for major property transactions. But when I taught law in Singapore, I have an informal observation. I think most cases about operation in Singapore were either about not paying dividends or somebody kick out the ball. So either it's about money or human or the management rights, and then people feel really pissed off. They want to seek remedy. And in China law, actually Chinese law maybe can address certain situation with appraisal remedy, but under Taiwan law, it's just impossible, especially for joint stock company. So there could be some merit, there could be broader ground obligation, but also the remedy-wise, it could be a lot of broader than just buying out minority, right? In theory, even though I understand, even in Singapore or UK, most of the remedy in the end is buying out minority. However, I have a counter-argument. There are certain proponents of having operation remedy in Taiwan as well. The beauty of operation remedy is it is potentially wide, unfairness. However, in terms of law, we hate uncertainty, right? When you cannot control what's going on with the code, we just don't like it. And unfortunately, what exactly is unfair is always uncertain. That leads me to my last point. It's beyond Professor Huang's presentation, but it certainly offers some food for thought for the future for myself. How to, even if we want to copy-paste the UK's Section 994, then how can we copy into civil law? And I contrast with Taiwan's experience with fiduciary duties. Our Companies Act also only has one provision. A director also duty to a company, duty of loyalty, and duty of care to the company. Otherwise, the director may be liable to the company, and that's a period. But if you're familiar with any case, though, you realize that fiduciary duty is more than just about loyalty and the care towards. There are other doctrines, like conflict of interest, good faith, etc. But when we can transplant a remedy that has been developed largely by case law into a more statute-based civil law jurisdiction, how to transplant that? If we simply leave local courts to make that decision, I'm not exactly sure it will end up in the way that legislator or professor would expect. But so again, I think I really enjoy Professor Huang's paper. I look forward to the final sharpening, and I guess you probably can split into multiple papers, not just one, I guess, right? But it's a wonderful paper, a lot of food for thought, and certainly offer myself a lot of ideas for future researches in Asia. So that will be my comments. I will pass on back to Steve.
That was a wonderful presentation and commentary, so thank you for that. And I'm going to go out to questions, but as chair, I've got some limited discretion here because Alan made sure that he would be the first question as the commentary was taking place. So we'll start with Alan, then we'll go to this table, and you can figure out we've got 2 questions there, and I think I saw, and then there. So that's 4, and then you can answer. Oh, we'll go 4, and then the next round we'll go, yes?
Thanks, Steve. First, I just want to I just want to thank Professor Huang for citing me in this work, but I need to acknowledge where credit is due. In fact, my own work was largely inspired by the work of Professor Ida, who's sitting over there, in his Jokyo-ronbun, which was published in the Journal of Jurisprudence Association, and it's probably the only monograph that I bought 2 copies of because it was so important I needed to annotate one in full. So I really acknowledge that a lot of my work is due to him, and in fact, he put out a new article in 2023 in the Asian Journal of Comparative Law, where he really describes the Japanese law as it is updated. So please cite that version because it's clearly updated and it's more relevant. And there's
23, huh?
2023 in the Asian Journal of Comparative Law. It's open access, so it should be very straightforward. There's a law reform somewhere along the way in Japan, so the issue of like premiums and distribution of what we call synergy value, I think the legal position has changed a little bit because of the details. I'll leave, I think, to Professor Ida to explain because he's much better at this than me. I also want to thank Professor Chen for raising the point, which I was hoping someone would, that it's not necessary that we just look at, say, common law, civil law jurisdictions just because you're a civil law jurisdiction, or we should always turn to Delaware as a common law jurisdiction just because of matter of habit. But I would like to offer just, I think, a couple of points. First is the straightforward point is I actually wrote a book about parts of what you would call appraisal, but I would call withdrawal. So the things about, say, abuse by controlling shareholders, for example. Actually, I put out a book with Cambridge University Press in 2022, so I'll be happy to share some of my thoughts on that. But I think the more fundamental issue here is, instead of looking at, say, just UK or Singapore, which I think Professor Chen has a good point, and I do bring up the UK in my study, I also looked at Germany. So Germany is another example of a civil law jurisdiction that has actually developed responses to the kind of the problems they're addressing in protection of minority shareholders. So I think that's also surprisingly perhaps a source of inspiration and maybe easier to justify in China, where perhaps there's some, Germany feels a bit more familiar in terms of, because of its civil law heritage. So I think the subject of comparison, I think, can be broadened successfully. But the more fundamental point I want to make is that of a comparative law. So in your study, in your 140 cases, you mentioned that 43 cases were what you call contract-based appraisal, which I think brings up very different issues from what, say, appraisal is really for, or even the new version, the abuse of controlling shareholder power. Because contract-based stuff is usually, even in many literatures, right, it's sort of kept separate from the position under non-contractual remedies. So I think that you need to perhaps consider how you might want to justify putting them all together, or perhaps taking those 43 cases out and writing separately about them as a matter of a negotiated exit. So perhaps by way of terminology, perhaps an alternative.
The 43 actually separated from the previous database.
I see, okay. So this because I think it's worth a paper on its own, and this is something that I've been always interested in, but I never looked into it. So I think it's really good that you're actually doing an empirical study of the contractual type cases. But for the non-contractual things, I think also there's an issue of comparison, right? Because now you're comparing 有限责任公司, the Chinese LLC with the Japanese KK. I mean, I guess there's a point to it, but perhaps the proper comparison is not just to the KK, but also to the Godo Gaisha, the 合同会社, which is actually the entity for closely held companies, but even though the numbers are not quite the same because it's not as popular in Japan. So there's a question of whether you want to broaden the scope of comparison, and even the Godo Gaisha has its own version of appraisal. So I think there's really a lot going here, and the data is so rich, right, that perhaps you might want to break it into subsets for more granular comparison while referring to each other instead of doing everything in one paper. So that's all. Thank you.
Great. Questions are always good when they lead to you needing to do further papers. We have two questions over here.
I learned a lot about the Chinese law today from you, and this is very interesting paper. And well, one thing I feel you try to discuss two different things in a double meaning. My meaning is, I mean that usually in Japan and the United States, appraisal right means that appraisal remedy for the merger, not for the operation things, and that usually called buyout, and and also you look like to treat both the publicly held corporation and closely held corporation in your one paper. And in Japan and in the United States, I think prevailing view is those are two different animals, right? And the prevailing view, I think the fair value is different. Fair value evaluation should be different in appraisal remedy against the merger and buyout remedy for the oppression, right? So, and also, what is a fair value? The criteria for evaluating the stock is inevitably different on a closed corporation without any stock markets and a listed company with a market price. And my question is, I don't object your attempt to study all those stuff as one point of view. The court will give the remedy to let the company or controlling shareholder to purchase minority stock and will give the fair value, with a fair value. That's such a system, all in one. That's interesting attempt. But so my question is, do you try to do this, everything in all one, or you think those are two different stuffs in the double meaning and try to argue differently? That's my question. And one more small question for confirming. What do you mean premium? So would you please define what's a premium? Thank you.
I feel perhaps it's better for me to
You want?
before,
Okay.
all of them, because otherwise I will forget.
We should have coordinated before, as SMU told us to do. But yes, yes, yeah, we'll do two at a time. Go for it.
Okay. Thank you. First, responding to I think that is a very good question about the non-statutory. Okay, perhaps I can use this opportunity to cover some bit of those things I have not. No, can you put that slide on again? And particularly for Professor, Shishido. Okay, your question, because I did mention in my paper the difference between the two type of companies, and I explained them separately. And actually, I also just the folks. No, not in my slides. My slides. So first, okay, to go. For those contract-based, like 43 or something, that one is not included in the slide, the database I presented earlier. That one is only based on the statutory provisions. And then I use this one as an explanation to say, well, why China, the number significantly lower than US and Japan, because we need to look at not only the cases brought on statutory provisions, but also cases brought on a contract-based grounds. So that's my point. So they are actually not included in those numbers. All those numbers there are not included. They're only included here. So that's why I purposely put the number. When I compare numbers here, actually those numbers do not include the contract base. So this one is separate. Okay. But still, it's difficult sometimes to tell. Again, that goes back to your question, how to define appraisal remedy. So because if you look at like those cases, like particularly you mentioned earlier, like those VAM cases, okay? If any, actually this one is not all the cases I got from the search. Actually, I cut down to this paper because I delete many cases which I do not think they belong to this category. For example, like those like a value adjustment mechanism in Chinese called 对赌. I deleted them because I do not think that one is a mechanism to protect a minority shareholder, and there's no need for them to exercise, to go to shareholders meeting, to exercise, to vote against. That one is almost automatic. It can be done actually, I think in future by like a smart contract thing, because that's a trigger event. If you do not meet the requirement, that will trigger that one. There's no need to vote against or something. So all those 43 cases, some of them similar to those statutory provisions. For example, I said statutory provisions, 5 long years, dividend, you can do this. In some contract, they said, no, not 5 years, too long, 3 years. Can this be okay? And as I said, when this come to the court, and the court look at this, no, because our law says it must be 5 years, cannot be 3 years. But this is based on the agreement of the shareholders. So should we respect the autonomy, or we think this one is go beyond the mandatory provisions of the law? That's the debate. Okay, and sometimes it can say, okay, not 5 years, 7 years, okay, longer, okay? And again, then whether this restriction should be held valid, right? Because the law gives you that right to seek after 5 long years, you do not get like a dividend, you can have this remedy, but now you say 7 years. Okay, so that is my response to close. Okay, and I look forward to that 2020. And if you can send me the paper, that would be even more efficient, so I do not need to look to search. Now, again, goes back to this one. See, I actually spend a lot of time explaining why there's a reason for scarcity of these related cases. Again, in those previous data, I deliberately separate them. Okay, one database for limited liability company or private company, and one for joint stock company, because there are only 4 cases. So even these 4 cases, okay, excluded from the database because I do not want to mix them together. And I agree with you, they are different animals. And I also explain why there's so few cases in the case of joint stock company. Okay, for example, okay, why, and like the reasons why the just so few, and there's no cases involving listed companies, none. I can, okay, also, no, and I think there's no need to introduce a market exception because in the US, there's a market exception that if it's a listed company, you have a liquid market. There's a market price. Why should you come to the court for this remedy? You just sell your shares on the market. You can do that. But also, you mentioned the German law and all things. I think, yes, they probably, I will look at those laws and in future. And indeed, I attempted to, to see whether all of things can be included in one single paper, or better to divide them into several papers. So thank you very much for your comments and suggestions. Thank you.
Yeah, I'll just be very brief. I just wanted to second the question by Professor Shiseido. I was very curious because I think you said there were no premium, and then I also saw that what you just now confirmed that there were no cases involving listed joint stock companies. So I hope in your future development of the project, you could say a little bit more about the valuation issue and the premium issue, because I don't understand the motivation to pursue appraisal in the kind of change of control transactions if there's not a premium, because that's what we see in the US with Dell and the later cases where it's just market value or deal value. So, but I'm gonna turn the floor over to the real expert here.
Okay.
Yeah, I'm Hirisa from the University of Tokyo, and I'm happy to read your paper and found you chose the country for the comparison with Japan, So I'm very happy. So I have the same question with Professor Shiseido, but I would skip that point, and I have just 2 comments for just improve your paper. So one is about the number of the cases increased in Japan. So you had the table, the number of the cases in the appraisal case in the US and Tokyo District Court, but then it's very different from the, say, merger case and the restricted share transfer cases, So the fair value idea is conceptually very different from that between them. The merger, regarding the merger cases, and after the reform of the 2005 corporate law, and the court can include the synergies or premiums, as you mentioned, into the fair value. But in cases of the restricted share transfer cases, there is no idea of such increasing the synergies or premiums. So then there's nothing. The increase of the cases in the Tokyo District Court does not relate to any change of the corporate law regarding the concept of fair value. That's one point. And the second is there is the very similar phenomena of so-called appraisal arbitrage also in Japan. So, the key player in Japan of the appraisal remedy is the hedge fund or activist fund, mainly Hong Kong-based Oasis fund is coming to again and again and raise many lawsuits, appraisal remedies. So, and in your paper, you mentioned in the shareholder ombudsman, but that is not related to the appraisal remedy. That is about just a shareholder derivative suit. So nothing, that is not related to the appraisal remedies. That's my observation. Thank you.
Okay, can I?
Yes. So
Can I very quick? Robin, I always like your research. It's a wonderful research. But I think I fully agree with Professor Shishido and Ida in terms of I think you're comparing a basket of fruits with one apple. But I think the difference is very important. I want to give you some suggestions. I hope it will be helpful, because in U.S. or in Japan, the appraisal is about merger acquisitions, and here in China, it's mainly about something like oppression. So in the case of oppression, of course, there's no ground to talk about premium, right? Only if you have a transaction, then you have premium. So I think your question about premium actually can be sort of resolved, if you separate these two types of things. But I want to, add this. Even in U.S., the court never says you need to include premium in appraisal. In fact, the court, for instance, in the Inri Trados case, the court says no premium, zero is a fair value. Zero is, even you pay nothing to the, so my point is, in US, there's not a rule. The rule just says you have to look at the stand-alone value of the company. It talks nothing about the premium. It's just to find out whatever the fair value it is. That's the first point. But I think the more important thing, if you look at this problem from the separation between merger and other cases, I think probably will be helpful for your consideration about contractual appraisal part. That is because in US, basically the appraisal is subject to the statutory merger, only the statutory merger case. But in case of statutory merger, it's a deal between the buyer and the seller. So in the merger acquisition agreement, you can agree on many things regarding appraisal, regarding the exercise of appraisal rights. Oftentimes, it's a condition for closing. That is, you cannot have certain number of shareholders exercise this right. However, it's subject to a complete different set of laws. It's subject to the contract law. It's not subject to the Delaware corporate law. So it's not an internal corporate governance issue. Therefore, anything said in the Constitution, in the charters of the target company will now be applicable to the buyer. So that's a different issue. Therefore, of course, you have the Constitution. It's not applicable to a third party, which is not part of your shareholder. This is important because that is in the US context. US context, acquirer can be completely nothing to do with you. It's not your shareholder until it buys you out. But in Singapore, in many other Commonwealth jurisdictions, that's not the case. Where you don't have a statutory merger, you have to be a shareholder of the target company. Therefore, you'll be subject to the constitutions of the target company. So I think this is a very different institutional setting. In one case, you are subject to the internal governance rules. That means you're subject to the constitutions, whatever it says about appraisal, whatever is said in the constitution. Whereas in US, you are an external party, not subject to whatever internal governance rules. Thank you.
Okay, so I've done a terrible job as a chair, and we've run out of time. But I think you started the presentation by saying that this may not be as interesting, but I think from the discussion it is. And I think we'll have to take some of the questions offline now because I've been told that we have to wrap up. Is that right? We could take 2 or 3 minutes. So I think that we had one question back there, and then one here as well.
Yeah, so I'll be very brief. So I just want to make one comment about the context. So, I agree fully, that. So my context is public health corporations in the context of a freeze-out. So I think that the appraisal remedy should be related to the standard of review that applies to the situation. So for example, in a 2-step freeze-out merger, so tender offer followed by a short for merger, like it makes a very big difference if the standard of review is entire fairness or BJR, because then the appraisal is really becoming the thing that makes the entire process non-coercive. So I think that's one thing, and then to compare it to the freeze-out merger, again, with the differences in standards of review that are relevant to appraisal.
All right, and very quickly, comments that you can take on notice, and then.
Thank you. Very quick comment. You mentioned the appraisal right through a contract, the contract-based appraisal right. I think there may be at least 2 issues, because that may affect the creditors, right? If the creditors' interest, because the appraisal remedy is from the perspective of the company, it's a purchase of its own shares, right? So it may negatively affect the creditors' right. And second, it may affect the interest of the other shareholders who didn't have the chance to sell their shares. So even if you allow the contractual the appraisal remedy, shouldn't it be offered to all the shareholders to prevent any mistreatment of other shareholders?
Okay, we can probably carry the discussion over, I'm sure, over coffee and everything, but I think we'll have to end the session, and I'll have to thank everyone for such engagement. And obviously it's a fascinating paper, that's why everyone's so engaged, and great commentary as well. So yeah, okay.
Thank you.
Thank you.